If you have a visa application pending right now, or if you are preparing to file one in the coming weeks, there is a procedural change already in effect that you cannot afford to overlook. The United States government has expanded its social media vetting program to cover a broader range of both immigrant and non-immigrant visa categories than at any previous point. This is not a proposed rule, and it is not a pilot program. It is active, operational policy already affecting case timelines across multiple adjudication channels. What the government reviews, which platforms are included, and what the impact is for your category, that is what this update covers in full. Welcome to U.S. Immigration News Daily. We deliver verified, actionable updates on USCIS and visa policy every Monday, Wednesday, and Friday at 2 p.m. Eastern. No rumors, no jargon, just the facts to protect your status. Let's get straight to the facts. Before we break down how social media screening works and who it affects, a professional reminder. This information is for educational and news purposes only. It does not constitute legal advice and does not create an attorney-client relationship. Social media review policies, disclosure requirements, and adjudication procedures can shift rapidly and affect cases differently depending on visa category, filing stage, and individual circumstances. Every case is unique. Always consult with a licensed immigration attorney before making decisions about your application or your online presence. The U.S. State Department began formally collecting social media identifiers, usernames and handles across designated platforms, from certain visa applicants in 2019. That program was targeted, applying primarily to applicants who had traveled to specific regions or triggered a threshold during national security screening. That targeted scope has fundamentally changed. Social media screening has moved from an exception-based tool to a standard workflow component, now confirmed across a wider range of immigrant and non-immigrant categories through updated State Department form instructions and USCIS procedural guidance integrating the review into I-485 adjudication. No new legislation was required. The agencies are acting under existing regulatory authority. What is new is the breadth and standardization of the review at scale. For a broader population, social media is now part of the standard package from the outset. Section 1. Main update. What officers review? When a consular officer or USCIS adjudicator conducts a social media review, they are examining publicly available content, public profile information, visible posts, photos, and associations accessible without a login requirement. The core function is cross-referencing. Officers check whether public content is consistent with the application and apply defined security screening criteria. This is not a general audit of personal opinions unrelated to immigration eligibility. What they do not review. Officers are not accessing private or locked content, direct messages, or communications behind a follower barrier. The review is limited to what any member of the public could access without logging in. That is the documented operational boundary. What platforms are included? The State Department's standard forms, including the DS-160, DS-260, and newly updated USCIS forms like the I-485, serve as the primary collection mechanism. They request handles and usernames across a defined platform list used within the past 5 years. Those platforms include Facebook, Instagram, X, formerly Twitter, YouTube, LinkedIn, and additional platforms. TikTok has been confirmed within the expanded scope under 2025 and 2026 policy updates. The forms also capture any additional platform not explicitly listed if used during the covered period. The 5-year look-back applies to all accounts, including inactive ones. Applicants with no social media presence can indicate that clearly on the form. What the form requires is complete and accurate disclosure of accounts that do exist. How the review works. After submission, a reviewer accesses the public-facing version of each listed account and cross-references visible content against application disclosures. If no inconsistency is found, the case proceeds normally. If a concern is identified, the case enters an additional review phase, resulting in an interview request, a request for evidence from USCIS, or administrative processing at a consular post pending secondary review. What triggers follow-up questions? 3 categories most commonly result in additional review. First, content inconsistent with the declared purpose of the application, posts contradicting a stated immigration intent. Second, publicly visible associations with individuals or organizations on national security or law enforcement screening lists. Third, posts that directly conflict with factual disclosures, inconsistent dates, locations, employers, or personal history. When identified, that conflict becomes a review point, requiring resolution before adjudication proceeds. Processing time impact. Cases that clear social media review without a flag continue on their standard timeline. Cases flagged for additional review can face delays from several weeks to several months. Neither agency has published a benchmark for the secondary review phase, and administrative processing at consular posts carries no statutory deadline. Section 2. Impact breakdown. Family-based applicants. Family-based applicants face review at the consular interview stage or at the USCIS adjudication level for I-485 filers. In both channels, social media is now a standard component, not an exception. Any inconsistency between publicly visible content and the application will require resolution before a decision is issued. Employment-based applicants. Employment-based applicants, including H-1B, L-1, O-1, and immigrant employment-based categories, are within the expanded scope. Non-immigrant applicants face review during visa stamp applications at consular posts. Those filing I-485 face review at the USCIS level. Content on professional platforms such as LinkedIn is not excluded. All publicly visible content is subject to the same screening criteria. Humanitarian applicants. For asylum applicants, U and T visa applicants, and special immigrant juvenile status cases, the review focuses closely on whether public content corroborates or conflicts with the factual basis of the humanitarian claim. A post contradicting a humanitarian declaration is treated as a direct inconsistency requiring resolution. The review is a factual consistency check, not an evaluation of the claim's merits. Section 3. Clarifications and misconceptions. Several things this expansion does not change must be stated clearly. This expansion does not affect visa priority dates. The April 2026 Visa Bulletin remains the controlling document for cutoff dates. Social media screening has no effect on when a priority date becomes current or how cutoffs move month to month. This expansion does not change annual visa caps. Statutory limits are set by law. Social media review does not consume visa numbers or affect the Visa Bulletin schedule in any way. This expansion does not change eligibility requirements. Substantive legal standards for all categories remain as established under current statute and regulation. Social media review is a procedural addition, not a new eligibility threshold. This expansion does not require applicants to have social media accounts. Those with no accounts should accurately indicate that on the form. Accounts set to fully private still require disclosure if the account exists and was used within the 5-year lookback. No publicly visible content does not mean no disclosure requirement. Failure to disclose an existing account, regardless of privacy setting, is treated as an inaccuracy in the application record. Section 4. Next steps. 3 practical steps apply in light of this update. The first is a consistency review. Verify that publicly visible profile information, names, dates, locations, employment history, is consistent with what is being disclosed on the application forms before submission. The second is a public information review. Access each listed account as an outside viewer would, without your own login, to see exactly what a reviewer would see. Knowing what is visible is a foundational step before any form is filed. The third is preparation for clarification requests. If any information in your background or public presence could require additional context, be organized and ready to respond promptly to an interview request or a request for evidence. Being positioned to respond accurately is the goal. Here is what we covered today. The U.S. government has expanded social media screening to a broader range of categories. Officers review publicly visible content only. Private messages are outside the scope. Covered platforms include Facebook, Instagram, X, YouTube, LinkedIn, and TikTok. The 5-year lookback applies to all accounts, including inactive ones. Family, employment, and humanitarian applicants are all within the expanded scope. This does not change priority dates, visa caps, or legal eligibility. Social media screening is now a standard feature of U.S. visa adjudication in 2026. The scope has expanded, the platforms covered have grown, and the population subject to this review is broader than ever. Make sure to subscribe and watch our next update on the April 2026 Visa Bulletin. This channel will continue to track all developments to protect your status. Stay informed, stay prepared.